Good morning, everyone. We are excited to be here with you today. I am Alina Ioana De Vos, and I am part of the valorization ecosystem in the Directorate General for Research and Innovation. Together with our partners and experts from the IP Help Desk, we are kicking off this series with today's session on IP in business collaboration for SMEs and startups in particular. Additionally, we invite you, please join us on the 20th of March for the IP and Artificial Intelligence Act session. This is perfect for anyone who is interested in artificial intelligence or has R&I results in this specific field. Next slide, please. Perfect, thank you. Horizon Results Platform. I would like to present you more a vision for the future, focusing on supply and demand of tomorrow. This is twofolded. First, we are offering boosting innovation matchmaking, which is a very important aspect. This will enable innovators to connect with third parties, including corporates, investors, Enterprise Europe Network, experts such as IP team. And it is important that also the beneficiaries publish their project results on the platform, and also the corporates and investors create their own profile on the platform. The second added value we would like to offer you are the services, which are new services for innovators. The platform will offer additional services such as thematic events, networking opportunities, corporate innovation challenges, which will be new, and partner search to connect you as an innovator with potential collaborations and collaborators. Next slide. As a concrete example, I start with the vision for the future, and I would like to go now to present, where we are at the moment with HRP. What we are doing currently is promoting the Empowering Startups and SMEs, which is an initiative that we would like to think that is very successful at the moment. And why is that? Is because we collaborate right now with Enterprise Europe Network and actually look for their open innovation challenges. In this case, I selected the example for Action Barcelona. And what we can offer you, it's the travel and accommodation expenses for SMEs in particular, participating, and this is important to mention, in a live pitch or brokerage event of your choice. So you can always let us know. I will share with us the contact details from our side, which event you would like to take part on, and we have a ceiling of 4,000 euros that we can accommodate travel expenses, tickets, or anything you know is needed from your side. The next one. All right, this is an additional platform to the Horizon Results platform, and this is the TV. And as it sounds, it's actually an audio-visual material that is offered in the platform. And we chose these success stories. And why it's that? Because first of all, we aim to maximize the visibility of various successful innovations, such as you, and offering guidance and access to key experts such as Anna Monistrol or Marco Gorini, that is here as an example. So why this slide goes very natural from the first Empowering Startups and SMEs, because as mentioned about Action, Anna, it's our counterpart there, and she is the one that connects with us on open innovation challenges, and we offer solutions. So we collaborate on a daily basis with her. And Marco Gorini here and Nadir, he is the one supporting, one of many, of course, from Enterprise Europe Network. He is supporting actively researchers in bringing their innovation to market, which is quite important to have such partners in your project life cycle. The next slide. Okay, perfect. So this year's series, we cover key IP topics essential for commercialization and valorization of intellectual assets. What is super interesting that the next one will be Artificial Intelligence Act. We have also an additional one, publishing and patenting, technology transfer, which is also will be our focus today and also moving forward, and the unitary patent. These topics have been carefully selected with IP experts, and these are the topics that we also see that the beneficiary are demanding for, and it can be an added value no matter the technology readiness level where you are. It's good to have an idea about these existing topics. And the last slide. Okay, as I mentioned, regarding the empowering startups or any other question, here are our details. Now I'll pass it over to the IP experts to share valuable insights into the IP in business collaboration. We start with this one for the year. Please feel free to reach us out no matter the question. There are not good or bad questions. We are here. And if you'd like to take part in the pilot, please send us an email and we'll get back to you ASAP. Don't forget to register. Next one is artificial intelligence. Thank you very much. And I wish you a very productive session.
Thank you. Thank you very much, Alina, for the very kind and precise introduction. Before we start with the technical content that was already brought up by Alina, I'd like to steal you another couple of minutes in order to, first of all, introduce myself. My name is Michele Duvini, and I'm part of the European IP Help Desk's training team. I will be your technical assistant today, so in case you've got problems with the video or the audio, that it doesn't work, just type it in the question part of the screen. I saw that somebody among you has already found this part, and a couple of questions have been written down. Please just communicate with us through the small question mark that you find on the right-hand side of your screen, and you have it there. You can ask all the questions and we will do our best to answer in the Q&A part of the webinar at the end. The question that we always receive is, when are you going to be receiving the slides and the recording of today's webinar? You will receive a follow-up email, which will contain the PDF of the presentation that you are about to see, but also a recording, a link that will allow you to watch the webinar anytime you'd like. And you can also distribute all this documentation to all your network without any form of limitation. In fact, for us, it's just a plus. Additionally, you will receive a feedback form after the webinar is over. We would be very grateful if you could fill that in, because of course it helps improving, and we can know what are the topics that you like the best and you like the least among ours. Please allow me just to spend a few words on the European IP Help Desk, which is together with the Horizon Results platform today, the initiative that allows us to join and be together here. It's a service initiative of the European Commission with the main objective of helping small and medium enterprises and researchers across the European Union, mainly understanding and using intellectual property and intellectual property rights. These categories that you can see here are the ones that statistically use our services the most. However, services are open to all physical and juridical persons who might have interest in the topic of intellectual property. And the way we help are the small clouds that you can see here on the right-hand side. There's a website, which is the key for the access to all the different services. Then we have trainings, which I will show you later on, publications. We have an ambassador scheme across the European Union. There are awareness raising events to which we are present, and there is also a helpline, which answers to specific questions by users and does that within 3 working days. The important about the services is that they are free of charge, everything that I've just mentioned, but they're also first line support, which means that the help desk is not going to file patent documents for you, but they are going to provide you the necessary information to decide whether, for example, it's the time to call a patent attorney for that. Or maybe if it's too early, or what you have is not rightful for a patent, and so on. So for the different but still important starting information on the IP discipline, the helpline and all the other services can be very, very useful. I see there is a question by Valentina asking whether we can support a non-Horizon EU project, an Interreg. We can if some of the parties are part of the European Union or are a Horizon-related country, which means that, for example, the service are eligible to entities that are either part of the European Union or that are part of the so-called Horizon-related country, for example, the United Kingdom, Switzerland, Turkey, Norway, and so on. If you need, however, information regarding the IP system outside these boundaries, you can refer to our siblings, which are offering the very same services that I've introduced before, but that are focusing on a different geographical area, which, by the way, is mentioned in their very name, like the China, India, Southeast Asia, Africa, and Latin America IPSME helpers. They offer, as I said, the very same services that I've introduced before, but with a different geographical scope. And this is a couple of examples of the literature that we have available online, and guides, fact sheets that are topic, country, and sector specific. There are infographics, and there are also case studies developed together with different European agencies and also the European Patent Office. They show the pathway from the lab to the market in different fields of research and markets. And so they're very interesting to see how a company made it from the research background until the business background. Again, the upcoming events, I'd like, as Alina has done before, to highlight the upcoming webinars on the 20th of March, AI Act. And I do that, we are especially proud of this webinar because personally, I think it's very interesting, very well explained by a distinguished speaker, Robert Harrison. So I would invite you, if you'd like, to register to the webinar and take part to it, because at least personally for me, it's going to be very interesting. But the offer does not stop there. And we have webinars coming up basically until the beginning of June. And if you miss one of our webinars, don't worry about it. They're going to be published online. And so you'll have the chance to see them at any time simply by visiting our e-learning page and clicking on the webinar you'd like to rewatch. Also, you'll have the link in the follow-up email to the e-learning page, and you can directly connect from the follow-up email there. Again, our contacts, but you'll have it in the PDF that you will receive. And now, finally, without further delay, I'm going to pass the word to our speaker today, Eugene Sweeney, that is going to finally introduce the topic that we are here for, interested in, which is IP in business for SMEs and startups. Thank you very much for this presentation, Eugene. The floor is yours. And
okay,
I'll come back for the questions.
So thank you very much, Michaela and Alina. I hope you can see the presentation okay.
Yes.
So I'm going to be talking today about IP in collaborations, business collaborations. And as Alina said, within this innovation ecosystem, collaboration is really important, but particularly for SMEs or anyone who is taking an early stage technology through to market readiness and the market itself. So I'm going to turn my camera off and join you later for the questions, mainly because we occasionally get some issues with some attendees have broadband issues. So what I'm going to cover, as I said, is mainly related to collaboration. It's mainly related to the strategic use of the intellectual assets and moving down that pathway towards innovation. So first of all, why bother collaborating? Why is it so important? And when you are collaborating, how do you manage and make best strategic use of your intellectual assets? Which of course, when collaborating means you're sharing assets and using other people's assets. And then I'll say a little bit about how we manage these shared assets and how we go around exploiting the assets to ultimately turn the inventions into innovations, innovative products and services. And I'll finish with a quick case study to try and illustrate some of the points I've been making. Actually, it's not really about bothering collaborating. It's actually, you need to collaborate. You have to collaborate to innovate. And you have to innovate, of course, because if you don't innovate, you will die. And this applies to all companies, whether they're large or small, whether they're involved in producing products or services. Because if you sit still, the competition will catch up and you won't see any growth and you won't remain competitive. And of course, SMEs in particular have limited resources. Unlike multinationals who may have their own research capability, SMEs have to rely on others, very often public research institutions and universities. So they have to, maybe they can innovate themselves, but there's a much wider pool of potential intellectual assets available for them outside their own small world. So partnering with others is essential, really, to provide access to both new assets and new opportunities. So where might you collaborate? Where do you look? Well, if you're an SME, you can look at your product or service offerings, and I'm sure you'll be able to identify some gaps, somewhere where it could be improved, for example. But maybe there are new products or services developed by other people, which could help your company's growth. You don't have to develop everything by yourself. You could license in, for example. So working with others can help fill these gaps, improve your products or services, and actually find new products or services which complement what you already have. But the other thing you can look at is your IP assets themselves. Maybe you have some intellectual assets which are not being fully used. Maybe they could be further developed with other people. Maybe there's some core IP which you can develop new innovations for. Or maybe there are applications of your existing IP in different sectors or different fields of use. And again, you can't do everything yourself. So maybe by collaborating with others, you can extract more value from your IP. And then there's the geographical territories. Many SMEs only have the capacity to operate in a limited area. By their very nature, they're small, medium, and can't hope to address everything without becoming overstretched. So maybe there are other territories you could move into with the same innovation, your same products or services, but maybe you could use your technologies in different fields of use. For example, if you're working in this sort of games sector, for example, and have some proprietary computer vision technology, computer imaging, it may be that that same technology has applications in the security sector or the medical imaging sector. So different market sectors, different fields of use. And again, working with others can help you unlock these opportunities. Now, there are many types of business collaboration. It's not just about research collaboration or licensing in, licensing out. There are things like supply chain collaborations, joint ventures, working to produce a startup with someone else, sharing the equity, and so on. But whatever the type of collaboration, there are challenges, particularly to try and align the individual partners' commercial strategies with the shared strategies. If you don't address this, you can find a potential collaborator becomes a potential competitor. So it's very important that when you enter these collaborations, you agree your strategies for both managing, protecting, and exploiting the intellectual property. And different businesses have different motives and they have different cultures. You need only look at say, a university or a research institution and a multinational. One is focused on research, publications, for example, peer reviews, whereas a multinational is more concerned with building business, as is an SME. So because they pull in different directions, this can cause conflicts, which can affect commercial success. Unless, of course, you think about them and you address them early. Now, when you're collaborating with people and you're trying to sort all this out, there are many different skills and resources that are needed. For example, pre and post deal, both scientific and technical support. When you're trying to align what you're trying to do, you need IP input, you need legal support, both commercial and licensing. You need to think about finance, investment, marketing, communications, many things. And it's inevitable that you need to find someone else. And Horizon Results Platform, as Alina mentioned at the beginning, is all about boosting this innovation matchmaking. And so the Horizon Results Platform can help you find collaborators, whether you're looking for investment, for example, or for business partners or business development assistants, or help with transferring your IP. The Horizon Results Platform is a great place to start. So collaboration is all about give and take. And what that means, it's about sharing your assets. So what do we mean by these assets? What are these assets that we're sharing? Well, it's intellectual because they're products of the mind. All the things on the right are, if you like, intellectual assets because they're the results of some sort of creativity or inventiveness, whether it's a work of art or a piece of music or a piece of software or technical invention or written work. They're all intellectual assets. And they're assets. We say assets because they have potential value and they can be traded. You can give them away, you can sell them, you can license them, whatever you want. But these are really important. And these are the core assets in any collaboration because they're the inputs to the collaboration and they're the outputs of the collaboration. They're the key asset in any project because they're the inputs and outputs, and they're the key assets in any company, the company's USPs. That's what makes the company different. But it's not just these, what I call intellectual assets. There are other intangible assets which are equally important. Things like know-how and knowledge and skills that people have. Sometimes these skills are intangible. Know-how, of course, is something that can be written down, but skills, for example, someone may be a great salesman or a great designer or a great software programmer. And of course, there's brand value, the reputation of a company, supported by a trademark, but the brand value can be worth a lot. So we're thinking about a lot of these intangible assets, of which a subsection might be the intellectual assets. Now, a few years ago, Ocean Tomo did a market study of looking at the intangible asset component of market value for Standard & Poor's 500. That's the top 500 listed companies in the US. And you can see as we go from 1975 through what's known as the knowledge-based economy that we're sort of in today, the percentage of intangible assets within the market value of companies is right up in the 90s. That was 5 years ago, 90%. It wouldn't surprise me if it's even higher now. So those are the assets that we need to think about and manage and use strategically. But states around the world provide legal rights to protect those assets or certain assets. And these are known as IP rights, IPR. And it's not only about patents, there are many different types of legal right. Patents for technical inventions, copyright will protect software code and written works and many other things. design rights, and importantly today, database rights, particularly as we enter this era of artificial intelligence. Many people are using the new artificial intelligence tools, particularly generative AI, to search and scrape away the data in those databases in order to create AI-based solutions. And the AI Act, which was mentioned earlier, and I'd encourage you to attend that if you're developing anything which uses databases or data mines or develops or uses generative AI tools, to attend that, because part of the AI Act is all about transparency and ensuring you adhere to European Union copyright law. So, for example, when you're using someone else's database, you need to be aware of the IP issues. There are other things in the AI Act as well, which will be covered. So some of these legal rights come into existence automatically, like copyright, database rights, and some need to be registered and sometimes examined, like patents, for example. But just because something comes into existence automatically doesn't mean you don't have to do anything. It's very important to keep good records so that you can prove date of creation. And particularly when you're collaborating, it's important to keep good records so you can identify who contributed to what. Now, there are some intellectual assets that I mentioned previously for which there is no formal legal right, no IP right. For example, knowledge and people. Well, these can be protected using contractual agreements, for example, a non-disclosure agreement or something in an employment contract and so on. And even if there is a legal right available, for example, you may be able to patent your technical invention, or maybe you can protect your source code, software source code using copyright. You may decide, actually, strategically, I don't think that protection is going to work for me, so I can keep it secret. And trade secrets is a legitimate form of protection, and there's a legal framework surrounding it, harmonized now in Europe. So that's another way to protect your intellectual assets. Most of these legal rights, patents, design rights, copyright, and so on, are time limited. And importantly, they're national rights. There is no such thing as a worldwide patent, for example. We're getting close to having we have the unitary patent in Europe, but in general, there are differences around the world in both the law itself and its interpretation. So if you are wishing to expand and trade outside the EU, then make use of the sister help desks around the world to ensure that if your IP needs to be protected, it's in line with the local legislation. So, a number of ways to protect intellectual and intangible assets. We have IP rights for certain types of intellectual asset, and we define just a bit on definitions. When I talk about IP, I mean an intellectual asset for which a legal right exists. But then there are other intellectual assets for which there isn't a formal legal right, but you can protect those using contractual agreements, confidential, non-disclosure, confidentiality agreements, employment contracts, or something similar within your contract or subcontracting terms. And of course, we have trade secrets. So why all this fuss about protecting intellectual assets? Well, states in general want to benefit society. And to benefit society, they need to encourage innovation and creativity to just continue to develop and make life better for society. But they realize that most innovations don't start from scratch. They're built on existing innovations. We just progress and move forward. But then if you're going to do that, then you need to avoid secrecy, so people know about these existing innovations and how to build on them, and at the same time to benefit inventors. So if I was an inventor And I came up with a great idea, and I spent a lot of time and effort, raised some money, used my own money to approve a principle proof of concept, build a prototype and a demo, and go on and form a company, build the market. I wouldn't be very happy if when I'm successful and people see that I'm successful, someone just comes in and copies what I'm doing and benefits from my hard work. So I might have a tendency to keep things secret, which of course wouldn't allow other people to build on what I've done. So this is the deal, basically the deal for most intellectual property rights. It's a legal right to prevent other people using your creation or your invention without your agreement for commercial purposes only. They can still use your work for research purposes, maybe for education, but if they want to use it for commercial purposes, they need your permission. And it's time limited. But you get that legal right in return for disclosing details about your invention. A patent, for example, needs to be what's known as sufficiently described, an enabling disclosure. It means there has to be enough details in there to allow people to replicate your invention. It doesn't mean that they can use it commercially. But those details are there so that other people can learn from what you've done and develop new innovations on top of that. That's the whole point about this particular approach. And it's not new. I give an example here from 1474, although there are other examples which go back much further than that, relating to the government intervention to stimulate innovation. But here this law is pretty much what we have today. It says new and inventive devices had to be communicated to the Republic in order to obtain the right to prevent other people from using it. So I like to think that IP protection isn't compatible with open science. It's actually the original open science. The motivation is exactly the same. It's to make the results of a lot of research, new ideas available to as many people as possible, to disclose it, make it open in order for other people to build on it. It doesn't mean that they can use it for free commercially without your permission. So if you want to go into open science, there's an IP Help Desk Bulletin number 7, which you can look at, and there's also an IP Help Desk webinar. So who benefits then? Well, the state avoids secrecy, so they can improve innovation capacity, stimulate innovation, and thereby enrich society. The creator benefits because they're able to prevent unauthorized commercial use, unless they come to some sort of agreement, it may be financial. But very important with any early stage or new technology is you will almost always need to find a collaborator or an investor, not just investing money, but it may be investing time, facilities, assets. And if they're going to invest in your early stage technology to make it market ready or to grow the market, they want to know they're going to get a return on investment. And having this limited monopoly that IP rights, IP protection gives you, gives them a lot of comfort. So the first question an investor will probably ask you is, what's the IPR position? And it's not just investors, it's if you look at the European Commission funding programs, for example, the ERC Proof of Concept or the EIC funding, European Innovation Council funding, an understanding of the IP protection is an important part of that process. Because if that's not the case, then the chances of going down that path to market readiness will be limited. So don't confuse the asset, the intellectual property or other intellectual assets or intangible assets. Don't confuse the property with the legal tools that exist, the legal rights, secrecy, contractual agreements. Don't confuse those rights with the asset, because those legal rights you can think of as legal tools which you may or may not use to support commercial exploitation, because the decision to support, the decision to protect is a strategic commercial decision. I'll say a little bit more about that later. So there are many ways to protect intellectual assets. Many of the assets can be protected by many different rights at the same time. For example, a piece of or an algorithm, if you like, a new method can be protected by a patent if it's technical, but also implemented in software with the code, which would be protected by copyright. And there may well be some trade secrets involved in the implementation, and the whole thing may be supported by trademarks. So the way what you protect, or the way you protect, really depends on the sector and the technology. And a study by the JRC in the ICT sector concluded and demonstrated that if you're operating in the software and services sector, then trademarks and copyright tend to dominate. Whereas if you're in the hardware telecom sector, where you have like longer gestation periods and lifetimes for the same technology, patents tend to dominate. As an example, this is an example of a new method to automate silicon chip design. Optimizes the production of these chips. So that method was patented, patents been granted, and going alongside that, there's lots of other copyright material. There's the software code which implements the method. There are various reports, papers, presentations, some of which have been published, some of which have not, but they all contain useful information and valuable assets. Also, the software code for the front and back ends, of course. But interestingly, the market research that was done, the due diligence and the patent searches as part of this commercialization process is also valuable, because that can provide useful information when you're talking to an investor or collaborator to justify why you think there's a real opportunity here and why the intellectual property, the patent that you've got, is going to be strong and broad. But there's also know-how, because patents are very often written to be as broad as possible. That means it covers the broadest area of the way to implement it, but there's often know-how involved to identify the best way to implement, if you like, tricks of the trade, and the best way to formulate the problem for the front end. So there are a number of things here, and also a trademark was filed, GF Express, GF because it's based on Galois fields, and Express because it does it really quickly. And all of this can help put a stake in the ground and help to build the brand. So when you're collaborating, it's important that you identify all the relevant assets relating to a particular invention, because a particular invention generally is surrounded by lots of different intellectual assets, as well as the core, maybe the core technical invention. So there may be reports, engineering drawings, which are copyrightable. There may be functional eye appeal designs. There may be trade secrets, and there may be intangible assets. And generally, in a collaboration, the output of the collaboration is a bundle of different pieces of IP or intellectual assets from different collaborators. So it's important, if you're a partner, an SME partner in a multi-partner collaboration, that you make sure that all the things that are relevant for your business are from all the different partners are identified, and that you're consulted in consideration of, you're consulted when the protection of these assets are discussed, particularly if you are going to be the commercial exploiter. And again, remember, just a reminder of the importance of keeping good records within the collaboration in order for you to show relative contributions. So we have these assets, we've spoken about their protection and their importance, but what about how to use it strategically? we think of the strategic use of IP as both a shield, sort of defensive, if you like, to ring fence your invention, to stop people entering your space, to create barriers to entry, which hopefully will enhance your competitiveness while you have that limited monopoly, but also maybe to file the patent to avoid other people filing protection in that area. So this is all very important when you're seeking investment, because this ring fencing, this limited monopoly, gives comfort to the investor that it might improve their return on investment. But you should also think about what we think of as SMEs, which is a bit more proactive and a bit more on the offense, if you like, where you use your IP to maybe generate new revenues, to license out perhaps to different fields of use or market sectors, maybe license in to access new technology, or with a joint, to develop a partnership or licensing arrangement. If two of you have different parts of the jigsaw, maybe you work together, and so on. So there are many different ways of using IP, and you have to think about what is best strategically for your particular business. As I said earlier, the protection IP rights is about disclosing disclosure in return for the right to stop other people using your technology or your invention commercially. So it's really about making a strategic commercial decision. So essentially, if there are commercial opportunities, and there may be different opportunities for different collaborators, because these collaborators come from different sectors, you have to ask the question of whether IP protection would support whatever business opportunity it is. For example, if your strategy is to raise further investment, maybe to form a spin-out, or to build a prototype, or to whatever, you do some market research, or whatever it is, then, as we said earlier, investors like to get a return on investment, and so protection would help. Maybe your strategy is to, okay, I'm going to keep everything secret, I'm going to ring fence things, I'm going to protect it with a patent. So you take a shield type approach. Again, you can't keep people out of your ring fenced area unless your IP is protected. Therefore, you would need to protect it. If your strategy is to license out to many different types of company in different fields of use or different territories, then you would need to have protection in those, covering those areas, because unless you can stop people using your inventions, then you can't license it out. But it may also be that when you look at the bigger picture, you decide that actually strategically it's better for me to make everything open, to make my framework, my framework freely available to anyone, because I want to build my business by providing services and products which sit on top of that. So it doesn't mean you always have to protect. It depends on the strategic situation. And again, it may be different for different collaborators. So you have to work together to make sure you align your individual strategies and don't tread on your collaborators' toes. Once you've done that, you obviously look to see if the benefits of protection are greater than the costs. And there are costs. Patenting is expensive, particularly if you want to cover a lot of different territories. But also the trade secrets involve expense. You have to put in place systems and structures to ensure things are kept secret. But don't think of this as a cost. Think of it as an investment, because the reason you're doing this is to improve the commercial opportunities of your business, to help you to grow the business and to remain competitive. So in the same way that you would invest in sales and marketing, you invest in protection. And you should think of it as an investment for the business. And again, maybe different for different collaborators. And if the equation is right, then invest. And again, different partners, when you sit down and work out together what you individually and collectively need. Maybe you also share out and divide up the way you invest in the protection. Maybe one partner will come, if they want to operate in the Far East, would cover the costs of patenting in those territories, whereas someone else would cover the costs of patenting in the US or Europe. But whatever you decide, you can't just say, I have a technical invention, therefore I will file a patent. You have to consider the exploitation strategies and pathways. You have to consider the strength of the IP to assess the opportunities versus the protection, and consider them all together and make that decision collectively. So we have some assets then, and what about the management of the assets? Thinking now more about operational aspects. We've spoken about the strategic decisions that you need to make and the assessment. So someone has to manage these assets in a collaboration. We think about the 6 pillars of IP management. It starts with the IP that you're going to use in this collaboration, and you need to make sure that you have the rights to access and use it. And maybe also there's some third-party stuff that you need. So you need to make sure that you can actually use it for the project. Now, using it for the project itself, for the research, if you like, is generally not an issue. But you also need to make sure that if you're going to need some of these assets from other partners, that you understand the position about getting those rights for exploitation and commercial use after the end of the project. Particularly important to think about open source software, because typically within a project, someone will want to download some open source software to do something like a visualization of results, or just some sort of tools or some solutions. But you need to be very careful when you start using third-party IP and open source software that the licenses that are attached to that will allow subsequent commercial use, if that's going to be the case. During the project, you have to think about capturing what you generate and sorting out the ownership and who's going to manage it, particularly since collaborative projects generally result in jointly developed and therefore jointly owned IP, and the ultimate result of the output is probably a bundle of different pieces of IP from different collaborators, some of which might be jointly owned. But you then, of course, have to assess what you want to do, protect it and exploit it, which we've just spoken about. Excuse me. And you have to think about what's going to happen after the end of the project, because IP management doesn't end when the collaboration ends. Someone has to continue to tell people about it, try to get it exploited, and someone has to continue to manage any deals or licenses that were done with the IP that came out of the collaboration. And of course, handle all the potential revenue sharing and so on. So some of these are operational, the bits at the start and the end. Management structures and procedures need to be put in place. And then there are some strategic elements where you need to have processes in place to make these strategic decisions. So let's have a quick example here of a collaboration. So this example has 4 different partners. Each of those partners is going off and producing different results, some of which they may do together, and they'll end up hopefully aiming to produce some sort of innovation. By innovation, I mean a product or service, not a result. And each of these innovations will probably require a different bundle of results. And some of them, of course, will maybe need to use background IP from some of the partners, or even third-party IP from someone else, maybe some open source code. And in general, you get to this point, and then you have to seek further investment, which implies a return on investment to take these innovations and get them market ready. And so the SME or the take to market partners, whether they're in the consortium, within the collaboration or outside, will need at some stage to be licensed with the different results owned by the different partners, signed or licensed under agreed terms and conditions. Maybe different companies will be licensed for different territories or different fields of use. And ultimately, we hope that these companies will get to market, find some paying customers, get some return, make them very happy, and usually there will be some flow back to the owners of the original results, who may not be commercial partners, they may be research partners. But if that happens, then everyone's happy. So as far as IP management is concerned, it's important that someone manages and coordinates things like the ownership and the management, relative contributions, sorts out the ensures that strategies for protection and exploitation are addressed, coordinates these transfers to the take to market partners. Doesn't necessarily mean doing it, but because the owners will have to be involved, but someone needs to manage and coordinate it, and similarly to ensure that revenue collection and distribution is appropriately managed. So it's important then to reach a common understanding if you're not to get lost in this tangle of different things you have to do. So you need to understand what the opportunities are for all the collaborators. Why are they in this collaboration? And who's going to address which opportunities? Will you do it individually or collaboratively? And how does this collaboration affect your commercial competitive positioning? Where are the gaps in knowledge? Why do you need to collaborate, and what do you need? And actually, a very useful tool is to, at the beginning of the collaboration, is to sort out a needs, contributions, benefits, and risk matrix. So you understand where everyone is coming from. Needs, for example, why, what are the challenges you want to address? What do you get out? What do you want to get out of it? What do you plan to contribute to the collaboration? And what do you want to get out of it? The end results, the benefits. And what are your main concerns and risks that we need to think about? So it's important to understand who needs what, when, and how. So before the collaboration, at the negotiation stage, you need to let people know about the existing knowledge and maybe the new ideas that you're coming with. During the collaboration, you need to know what background and other assets are needed by the different partners, how they're going to be managed, and how they're going to be exploited. And again, after the end of the collaboration, who's going to look after these collaborative results? And that means that at each different stage, you need to think about different agreements to put in writing so that everyone understands where they stand. So before the collaboration begins, you're going to have some exploratory discussions, and it's always good to do that using a non-disclosure agreement. During the collaboration, so the collaboration itself, the exploitation of the results, and after the collaboration is normally covered by a collaboration agreement. During the collaboration, you may produce some jointly owned results, in which case it's necessary to have a joint ownership or joint exploitation agreement. And when you come to commercialize, the results would be transferred to take to market partners under some sort of transfer or license agreement. And those would continue after the end of the collaboration. So, as I said earlier, it's very important to understand that collaboration works best when everyone has a clear understanding of how they're going to work together and how things that are going to be owned, used, and protected for everyone's mutual benefit. So during exploratory discussions, we're talking about maybe you come into the room and you make people aware of what you've got, the background information. Yeah, when you're doing this, you need to make them aware if it's protected or not, and then clarify that the use after collaboration. So you will say, well, we have this existing background IP. We're going to make it available free of charge for use during this project to develop whatever it is we're going to develop. But after the end of the project, if you, Mr. SME, are interested in using it for commercial purposes, you need to come back and get a license under some agreed terms. You may have some unprotected or confidential or secret information that you want to put on the table, but you should do this only on a need-to-know basis with a non-disclosure agreement. And you should also consider whether you want to supply something as a black box or a service rather than disclose everything. For example, you may have some software that does something very clever. Do you really want to make the source code available to everyone to play around with? Is that necessary? Or can you just provide it as a black box or a service? Whatever it is, if it's confidential, you should mark it as confidential. And if anything is disclosed verbally, then you should minute all discussions and note that the information was confidential. If you're bringing new ideas, again, you should discuss that under a non-disclosure agreement and disclose, if you can, the potential of the ideas, but not necessarily the how, unless you feel that's a good thing to do. Noting that you can't protect ideas per se unless they're expressed in some tangible form, written down, built, drawn, or whatever. That's not to say that you shouldn't trust your potential collaborators, but it's always good to just be a little bit wary. Word about non-disclosure agreements. I think you should always have an NDA prior to any discussion relating to something that's going to be confidential, or you note it as confidential, mark it as confidential. But remember, a non-disclosure agreement only covers disclosure. It doesn't cover commercial transaction. So you need to make the purpose of disclosure clear in the non-disclosure agreement, and it doesn't go beyond any exploratory discussions. So you can't continue to think you can have confidential discussions once the exploratory discussions are finished. And I also want to mention, because as we do live in a global marketplace now, and if you're collaborating with someone outside Europe, sometimes the confidentiality and trade secret laws differ. So make sure that your non-disclosure agreement is watertight and serves its purpose. During the collaboration, of course, it's all about making sure you have management structures and responsibilities to assess the new IP, to capture it, to agree terms of joint ownership, and implement the exploitation. So you need to ensure that the collaboration agreement covers all these management responsibilities and structures and procedures for doing this. So a bit more now about capturing and so on. Capturing the collaboration outputs. It's important that you try and capture these as soon as possible. And you need to determine who contributed, what did they contribute and how much, to determine the ownership. And it's important to think about other potential people who might have contributed. For example, students, advisory board members, and so on, who are not party to the collaboration agreement and therefore may claim some small ownership of the result themselves. So again, something you can address in, say, if a student is going to be involved in this project, that the terms of their involvement are clear, and advisory board members as well. Again, I repeat again the importance of keeping good records. Maybe there was other external funding or facilities used which had different terms and conditions about ownership. Make sure you've checked all the confidentiality agreement and ensure that there haven't already been any publications or disclosures, particularly important if it's a technical invention. So universities like to publish. Within Horizon Europe, there's a requirement that they give notice to the other partners to object the publication for legitimate reasons. And it may be that the SME who is thinking they might want to use this result to commercialize, that they get sight of this. so they can say, hey, hang on a minute, we should patent it before we publish it, or I think this should be kept secret for commercial reasons. And these are all legitimate reasons for, within Horizon Europe, for delaying or preventing the publication. So again, make sure that, as I said earlier, that even though you're an SME and you've not been involved in developing that particular result, that you have input if it's relevant to your business. And again, anything else needed to use that IP. So a word about ownership. The default position without a written agreement is that each joint owner owns an undivided interest in the whole work. It doesn't matter who contributed most. And each has the right to exploit without the other's permission, but has to pay the other joint owners equal shares of the earnings. And you can't transfer or do an exclusive license without the other's permission. And if someone infringes and you get some damages or compensation, you have to share it equally with the other partners. Well, I'm sure you can see this is likely to cause some issues, particularly if one partner contributed quite a lot and the other a little, to have to pay equal shares to the other partner who didn't get involved in any exploitation or infringement proceedings or any of that work, that you should have to pay. So it's always best to have a written joint ownership and exploitation agreement, and have within the agreement, within the collaboration agreement, the processes needed to agree these relevant contributions. It's also a mandatory requirement under Horizon Europe funding. It's a requirement that you have a written joint ownership agreement, as it says in the grant agreement, to comply with the terms of the grant agreement. So what sort of things should you agree? Well, there should be clear management activities to decide things like relative contributions, who's going to manage, how the costs and revenue is going to be shared, who's going to pay and arrange for protection, and who's going to make decisions, and so on. This isn't an exhaustive list, but the consortium agreement should explain the process. That's the overall collaboration agreement. And then for each result, you would have a joint ownership agreement, which would specify the terms and conditions. And it's not just for individual research results that you have to do this, it's for bundles of IP, because you're collaborating because there's likely to be several different results from different partners, some of which may be jointly owned, which come together to produce the final output of that project. And you have to sort out the same things. So how do you agree? Well, the best way is for the creators to agree among themselves in writing what the relative contribution is. This is an approach I've used in the past. You just say, can you go away and agree amongst yourselves and send me something in writing? So you have emails or something written which says, you know, we agree that so-and-so contributed 70%, the other party 30%. It helps, of course, if you've got good records, because if that doesn't work, then you can find some other way, which is a bit time consuming. Look at timesheets if you've done that, or anything else if it's a formal project. Otherwise, if there's no agreement, you go to you let the different parties present their case to an independent adjudicator who will make the decision. That's the process, if you like, which can be put in the collaboration agreement, but in practice, really the quickest and the easiest is for the creators themselves, the individual partners, to agree in writing what the relative contributions are. Now, there's a bulletin soon to be published by the IP Help Desk. I think it's getting ready for publication, and that will say a lot more about joint ownership agreements. So assessing and protecting the results, well, they have to reflect the commercial strategies of all the partners, and that includes licensing out to third parties. you have to understand who's going to make decisions and manage the protection. And as I've already mentioned, it's important that all the commercial partners have a say in that, regardless of whether they were involved in the creation of those results. If it's going to be protected and there are costs involved, or it's going to be kept secret, who's going to do that? How are the costs going to be shared? Who's going to host whatever it is? If it's something secret, who's going to put in place the secrecy infrastructures and so on? And then what are the rollback options? What if some partner decides they don't want to continue to file a patent in Europe? Are there options for other partners to have rights of first refusal, for example? And how will infringement be managed? Then you have to agree about the exploitation of the outputs. So you have to sit down and sort out strategies and the pathways and responsibilities. Some of the things I've just mentioned, and how it's going to be transferred. Now, protected IP is usually made available under a license, so you transfer it to your commercial partner and then the consortium, or you transfer it under a license to someone else. And for all these things I've just mentioned, I'm talking about the processes. I'm outlining the things that have to be done. So the consortium agreement needs to outline the processes and how this will be managed. But the joint ownership or exploitation agreements and the bundles of IP are separate agreements which come out, which cover the terms and conditions related to these points. Okay, so if we look at these pathway from results to revenues, from invention to income, whatever you want, you have this pathway going from basic research right the way through to market deployment. And at the early stages, the value is relatively low, basic research stage, and the risk is higher. So people are a little bit warier, less likely to invest, or if they do, then they'll take a high percentage of returns. But as you go down this pathway, and you get closer to market readiness to scale up being validated or having proof of concept, then the value of the result increases, the risk reduces, and it makes it a little bit easier to convince partners to move forward. Because just having a collaboration to produce a result is one thing. You will always need to involve others, as I mentioned earlier, in order to take you along here. And the issue, I think, is one of convincing different people to jump on the bandwagon with you. In general, it's very difficult to convince people at the basic end. And so you say, oh, I'm going to have to invest into a proof of concept, and then the investor might be willing to support my spin out, or the licensee might be prepared to take a license. And in general, it's about doing this convincing job. The example I gave earlier about GF Express, having the due diligence reports, the market research, the patent landscape is all part of that convincing argument. And it's quite difficult, and it's well known in the tech transfer business that you have this valley of death. And so many good inventions get lost because they can't move down that pathway, because they've been unable to convince whoever they need to convince, whether it's for raising finance or take a license or become a partner. So this again is where Horizon Results platform, which is trying to sort of boost this innovation matchmaking, becomes very, very important. So it's very important when you're thinking about this to understand the landscape. You have some results and you have different commercial opportunities, maybe from the different collaborators who have to get across Death Valley to get to the point where you've delivered your project, your product or your service. And Death Valley, you need to understand where all those, where the minefield is and where the mines are. And it's not just about technology. You have to consider regulations, finance, IP rights, freedom to operate, market issues, other technologies or solutions which solve the same problem, standards, and so on. And whether you need to do any work, additional work to get you past some of these barriers. So it's important that you understand the whole landscape, not just the technical landscape, in order to get the strategic intelligence you need to develop a credible strategy and then to plan and justify the pathway. Because whatever it is, it's not going to be a straight line. You're going to have to either go through, over, or around some of these obstacles. And so the Horizon Results Platform is a great tool for helping you to find, to matchmake and work with other people in this innovation ecosystem. So once you've understand the landscape and where the mines and barriers and obstacles are, you need to identify the best way to get where you want. And there are many different, I like to think of this as the routes and the vehicles. Licensing and forming a new company is probably one of the most common way, but there are other ways as well, making things free or open, not-for-profit foundation, joint venture, and so on. There are many different routes. And you choose these routes knowing what the various obstacles and enablers you need to get around. So you may have regulatory approval or health and safety approval needed, or you have to adhere to a standard, whether it's a technical standard or a requirements standard or health and safety standard and so on, or freedom to operate. Maybe you need to raise money to take a license for some third-party IP and so on. And then you have the requirements to enable you to get over these obstacles. Do you need to raise finance? Do I need to build a prototype in order to put it through a standard requirement certification, or do I need to do field trials and so on? So these are some of the things you need to think about. And I would just say that it's best to only have one driver for each vehicle. You may have different routes and different vehicles for the different opportunities, and there may well be different SMEs driving each vehicle. And some of these obstacles and enablers may be common to the different collaborators. And so it may be that some of the things you need to do, for example, regulatory approval or standard certification, is something that can be shared between the different commercial partners. Again, it depends on the case, but you need to think of it, think of this as a checklist, if you like. So just looking at how you provide access to the IP. So intellectual assets, like physical assets, are valuable and they can be traded. You can buy them, you can sell them, you can lease them, you can give them away for free, you can use them as collateral against some sort of investment, or you could use them as joint venture. There are lots of different ways of using intellectual assets, many more than just a physical asset where you sell it or buy it. I've given a list of a few here. Things like patent pooling are important, where there's a lot of clusters of inventions. For example, things like 5G, where it makes sense to go via a patent pool or a patent aggregator. But in general, licensing or startups are the two most common ways of transferring technology to a new take-to-market partner. If we look at the two, with a license, you're looking for someone who already has expertise in that sector and resource to take your not quite ready, market-ready technology and turn it and take it to market. And you can have different licensees in different geographical areas and different fields of use. With a new venture, you have to form a company that's going to acquire that expertise and resource, and also to build a critical mass of expertise who are committed to this small new venture and enthusiastic. Um, so you tend to think of licensing where there's an established market and established suppliers, and what you have is some evolutionary or incremental technology that fits a gap in someone else's portfolio, and they would be willing to take it on board, do the work to get it ready for market, take it to market, and then share the revenues with you. With a new venture, it's generally when it's a new paradigm, it's a new market, there are new suppliers, or there are no suppliers, and you're going to be the new supplier. And generally the technology is sort of revolutionary or platform technology, or delivers a unique business advantage. This can, of course, be a combination of technologies. We've seen examples in the IT sector, for example, where a combination of location-based services with, say, ride-hailing apps, taxi apps, has led to a new market. So with a license, you have a low financial commitment. You're basically seeking someone to take your technology under license, and you can get some early returns. You can get a payment on signature, you can get royalty payments when there's success, and it may grow over time. With a new venture, you need to raise the capital to create your team and your company, so there's more risk there. And the returns might take longer, because you'll only get a return when the company, when the shares of the company, if you like, are tradable. They may take longer. In some sectors, they can be very quick, particularly in the ICT sector. You can get a return in 2 or 3 years, but those returns could be enormous, as we've seen. Snapchat, I think, after 4 years was valued at 4.2 billion. So, and there are plenty of examples of disruptive innovations, breakthrough innovations, unicorns, and so on, who have gone down that route. So, licensing in general is about granting the right to use protecting IP under certain agreed terms and conditions. And there are a whole load of these different terms and conditions. And IP Help Desk Bulletin number 1 discusses IP licensing, and we talk about the key ingredients in a license, and there are many of them. And each of these terms can be, whether it's to do with improvements, the length of the license, whatever, the territory, the field of use. Every clause is a negotiating point wherever you are in that value chain. So looking now at the end of the collaboration, well, the end of the collaboration is not the end of the IP or the intellectual asset. So you have to agree within your collaboration agreement what happens when it ends or is terminated. And this covers things like the terms of access and use of the IP post-collaboration, its ongoing management of jointly owned IP and protection, covering all the things we've mentioned before, and who's going to manage and monitor existing licensees or existing sort of equity ownerships, for example, and any derivative works, including IP auditing. And who's going to monitor the market and decide if someone is infringing, and how will litigation be managed. So the consortium agreement needs to have in place a process for agreeing all this, and the agreement for the different bundles of technology, all the individual assets, would cover the particular terms and conditions. So let me finish now with a case study to demonstrate a number of things. One is getting across that valley of death to unlock that exploitation by convincing investors. And the other one is about selective licensing to avoid overstretching an SME. And the other interesting point is, in this convincing argument, often producing something that's cheaper doesn't mean you make a convincing business case to an investor. As you might have guessed, it's to do with the contact lens, and it's to do with the daily disposable contact lenses. This was developed by 2 individuals who were working in the industry, and they were two individuals, and they realized the potential and the fact that the cost of protecting and patenting this worldwide was beyond their means. So they came to the company that I used to work for, which was a technology investment and development organization, and we managed the IP. So we paid for it and sought to exploit it. And of course, if we were successful, then these original owners would benefit. And interestingly, when they were trying to, they of course wanted to form their own company and to seek investment, but they discovered often if the technology is cheaper to make, it doesn't make a good business prospect without a new business model. So this technology enabled contact lenses to be made really cheaply. So cheaply, we decide with a new business model that you can throw it away every day. It doesn't mean it self-destructs every day. It'll last for several days, but that doesn't make a good prospect if you're trying to license it to an existing contact lens manufacturer. The other problem was that early exploitation efforts failed because the investors weren't convinced that you could go from this proof of concept in a laboratory to mass production in a factory, and that was difficult. So we had this valley of death approaching. So money was invested in building a pilot plant, and that pilot plant was very successful and demonstrated that scale up was possible. And on the basis of that, the original inventors who were going around trying to form their own spin-out company to do this managed to convince the investors and created a startup company called Award PLC. They, of course, needed a license to do this. And whilst they would have loved, I'm sure, a worldwide exclusive license, we decided strategically it was important just to license them for the UK only. You don't want to overburden a startup company with too much to do. So they've licensed for the UK only. They were very successful in making and distributing them through major UK outlet Boots the Chemist. And on the basis of that success, we of course were seeking further licensees throughout the world, in the US, in Australia, Japan, and so on. And on the success of Award, these other licensees became convinced, and Bausch & Lomb took a license for the US market. So you see this snowball gathering momentum, and they took a license. They liked it so much they ended up buying out the Award, and of course the inventors were very happy. Bausch & Lomb then came back and wanted an exclusive worldwide license. Now in this case, we granted the license because they were a large international company who were able to manage that sort of scale of operation. It's their baby, of course. You have to make sure you don't just give it to anyone. And so in the end, everyone was happy. We were happy because we got a return on the commercialization. The inventors were happy. They got an early exit from their spin-out company, and Bausch & Lomb were very happy because they had a worldwide license. So the lessons, a number of lessons. One is you need to tread carefully and work out how you get across this valley of death. And you need to think about maybe different types of licensing across different areas, maybe different fields of use, not in this case. And that helped by not overstretching the SME initially. It helped them establish the market in the UK, which set the snowball rolling and enabled the rest of the market to establish successfully. So in summary then, collaboration, when you're going to collaborate, you have to work out your mutually beneficial business opportunities. It's important that you understand the needs, expectations, and contributions of all the partners, and that you work together to develop coherent individual and shared strategies for managing, protecting, and using or exploiting the IP. And bearing in mind that you can transfer intellectual assets and protect them in many different ways for many different purposes under different terms and conditions. It just depends on the sector and the technology. And finally, remember, it doesn't end when the collaboration ends, and you have to think about how you're going to manage this after the collaboration terminates. So preparing in advance and planning in advance is very important. And without that, you probably won't be able to be so competitive and grow as much as you would like. So there's further help. The IP Help Desk and Horizon Results Platform we've mentioned already, and that there are a number of relevant publications that you might want to look at, particularly this package from the IP Help Desk, bringing together a number of things to do with knowledge valorization in research and innovation collaborations. And there's another little chart infographic there. And recently, or just last year, about a year ago now, some codes of practice were published by the Commission. And the one in the middle there is about industry academia co-creation or collaboration. So with that, I will end and hand over to Michele and take some questions. Thank you all very much.
Thank you very much to you, Eugene. As Eugene has already introduced to you, we are now open for questions. Let me just open up the Word file that contains a couple of questions that you already asked. I have to say that the majority of all the questions are actually more administrative questions, and I've answered them already. One of them, for those of you who have connected later, please be reminded that you're going to be receiving the slides and the recordings of today's webinars as soon as possible. There's going to be a follow-up email with a PDF file and the link to watch the recording at any time you'd like. The second question is if there are insurances that may be applied for patent protection.
I think there are.
Say in case of
yeah, I think there are some companies who will think about doing this, but it's more larger companies do that. I'm not that familiar with it. I don't know if you know any more, Michele. It is, there are companies that do that, but I would generally say you have to do your due diligence at the start when you're looking to protect something, and just having an invention and filing a patent isn't enough. You need to make sure that patent gives you the breadth and depth of protection that you want for your particular application. And be wary of some patent attorneys who will come back and say, well, we put it into the examiner. They say, if I remove this claim and I remove that claim, then we can probably get it granted. So whilst you may have a granted patent, you need to ensure that the patent is strong enough to do what you want, because if by removing certain claims people can just work their way around it, it loses its value. So,
question number 3. It's a lot of information that you have shared, Eugene, but the user is asking whether you may perhaps share some common ways of start dealing with the complex IP processes in the consortium, and do consortium usually work with consultants or legal experts, and are there other EU IP services that can provide full support in all elements of the project? How to start with it?
I think I'm sorry if I gave you too much information. It's complex, but I'm not sure how complex it is. I think when you have a consortium, you come along and you say, I have this back, you know what you want to produce, and you know the component parts of what you want to produce, and you know who's going to contribute to producing it. So you start with the background. There's always going to be background. And so the individual collaborators will say, well, I've got this technology which I want, we think can be built on. So you know who owns that, you know how it's protected, and you decide, in general, with Horizon, it's made available free for the research project. But then and there's usually an annex in the consortium agreement. You say, well, for commercial use after the end of the project, we need to agree terms of use, a license or something. So that's for the existing IP. And then you will have your collaboration. You'll have different partners, each of them producing different things, ending up with something at the end. And if we take something like, say, a decision support system, that decision support system may be based on a database which is owned or created during the project. It may involve some algorithms for interrogating the database. It may involve some visualization of the results or some analysis of the results. So these are all different components which may be done by different partners, but you will know as part of your project plan, your proposal, who's going to produce what, and you know what the results are going to be. So you can look at each of these results and decide, how you want to deal with it. So you don't normally work with IP consultants or legal experts at this stage. You might, when it comes to the point of saying, well, I've got the result, we thought about it, we know it's technical, we've known it's going to be technical from proposal stage, and we know that it's potentially patentable, therefore. So maybe at that stage, when the decision is made that it's going to be useful strategically, you want to protect it, then you might get a legal expert involved. The IP help desk won't help with filing patents and things, but it might be able to help with understanding the rights or the access rights. At the end of the day, the beneficiary who generates the result owns the result. It's not the consortium. And again, you generally know this because you've written it in the proposal. So you can start thinking in advance at the early stages about the different results, who are potentially the contributors, who wants to exploit it, will the material be made available under a license or free of charge, and so on. So there is a lot you can do at the early stage. And as I say, consortium agreements and their standard consortium agreements ought to include the processes and the management structures, but they won't include the detailed terms that are covered in the joint ownership agreement. As I said, regarding templates on joint ownership agreements, I'm not aware of any. Maybe the IP help desk can point to any. These are pretty much individual. I think you have some of the terms and conditions. It's essentially who's going to manage. Well, first of all, relative contributions. Who's going to manage, i.e., host it, look after it. Who's going to decide how decisions about protection are going to be made, dissemination, exploitation, and then how are costs and revenues going to be shared. And those, maybe if one partner decides to bear all the costs of filing a patent, then they take a larger share of the revenue. So if it was 50-50 relative contributions, if one partner is going to pay for all the patent costs, maybe the revenue that they get might be shared 70-30, and so on. It's that sort of level. As I said, the next bulletin, the IP Help Desk bulletin, will include some things about joint ownership and how you sort out the relative contributions and some of the things you need to consider. I'm not sure exactly the date when that's out, but if you sign up, if you're not already signed up, then you will receive it when it's available.
Yeah, some of the participants have already taken advantage of this possibility and registered to the newsletter.
Okay, good.
I don't see any new questions, and but I'd like to remind, just in case, for example, you should have one last minute question, but we have already closed the webinar. You can redirect that question to the helpline of the European IP Help Desk, and they're going to be very happy to answer you, of course. And otherwise, we will be back in our very interesting with the HRP on the 20th of March, as Alina has already introduced before. And that is going to be, as also Eugene pointed out throughout his presentation, a very interesting class on artificial intelligence, specifically in the piece of legislation that was released a couple of months ago by the European Commission, so the AI Act. If you're interested in the topic, don't miss it, but you'll be able to see it anyway.
And I would add that well, the legislation is quite new, but you as users, there's watch out for in April, mid-April or thereabouts, the Commission is planning to publish a code of practice on the use of implementing the AI Act. So that's also worth.
We will talk about that also.
Yeah.
And okay, I will then now close the webinar at the moment because I see we are a little bit out of time. Alina, if you'd like to say a couple of words, you're very welcome to.
Thank you very much,
Eugene. So, and thank you very much once again for the opportunity of joining the courses.
Thank you. Yeah.